Welcome to our welcome to our webinar today, 2026 employment law changes what small business owners should know. Sorry. We're excited to have you here. We have a lot of people who are still joining, so we're going to give them just a minute to get situated. In the meantime, if you want to put in the chat where you're joining from, and if you're like me and you've been watching the Winter Olympics, why don't you let us know where you're joining from and what your favorite Winter Olympics sport is? I know that my colleague was saying he's been watching a lot of curling today. I was watching some ice dancing yesterday. But we're excited for our program. Let us know. Ice skating. Good call, Camille. Where you're joining from. Let me just cover a couple of preliminary matters. We're going to be talking about a lot of changes. We want to be able to answer questions that come in. It's difficult for us to do that in the chat because, as you will see, there are a lot of people on the webinar, and the chat usually gets going kind of fast and furious. So if you could use the Q&A function at the bottom of your screen to submit questions, we'll try to monitor the questions that come in and answer as many as we can throughout the program. Some we'll type, some we'll answer live. We are hoping to save a little bit of time for Q&A at the end. So as we cover different topics, if you have questions, put them into the Q&A, and feel free to use the chat to chat with your fellow webinar attendees and small business owners, and to network. It's a great place for that. So thank you very much. Well, we still have people joining, but we're covering a lot of ground. We'll let them get situated as they join, but exciting. It seems like we have people from all over the country that enjoy all sorts of events. I think that's one of the great things about the Olympics. My name is Ryan Parker. I'm the Chief Legal Officer at SixFifty. For those of you who may not be familiar with SixFifty, we are an HR platform that helps businesses of all sizes to create the business documents they need, including offer letters, employment contracts, employee handbooks, addenda, and separation paperwork. And we have a research platform that helps small business owners to research employment laws and to understand their obligations. And so we spend a lot of time thinking about the law. We're always updating our tools, and we're excited to tell you about some of the big changes that have already happened in 2026. And we'll pull out our crystal ball and maybe make some guesses about some additional changes that we might see. I'm excited on this program to have two of my colleagues with me. First, Mira Bashir. Mira, we're excited to have her joining the webinar. Mira is a member of our legal product team. She has been instrumental in creating our posters tool. She is really incredible when it comes to legal research, very thorough, and probably knows more about employment law posters than almost anyone in the country. So very excited to have Mira here. Lots of interesting things about Mira, but she was telling me right before the webinar, we were talking about interesting facts, that she actually grew 4 inches after she was, I think when she was 24. She said, usually most people have stopped, and she moved from short to medium height. I thought, man, if I grew 4 inches at that age, I could have been maybe in the NBA. But also a fun thing about Mira is that she in the past has done stand-up comedy. So if anyone can keep information about labor law posters light, it might be Mira. So thank you for joining us, Mira. We're excited to have you. Also with us today, we have Seth Baraney. Seth is a Atlanta Braves fan, keeping a low profile, living in Pennsylvania. He is also a member of our legal product team, a proud graduate of the Ohio State University Law School. I'm a Michigan law grad, but we still get along pretty well. And Seth helps us with our consumer data privacy tools and all sorts of things on our employment law tools. We're really grateful to have Seth. Seth recently helped his team to a league softball championship. I think he's still maybe wearing like a big ring from that, or I don't know exactly what you guys got, but Seth also is a big fan of music festivals and a lot of fun to work with. So we're grateful to have Seth here as well. So I want to just start, and I'm going to get to the agenda in a minute, and take a look back at 2025. A lot of things happened in employment law. And so let me just touch on them quickly, sort of set the stage for what we're going to talk about today. We had a new presidential administration that took office in January, and that really brought an end to a lot of things that we were thinking about in 2024. Things like raising the standard for exempt employees, the salary standard, a non-compete ban, those kind of things. It also changed priorities for the EEOC, and we've seen a lot less action from like the NLRB and DOL in a lot of areas. And so that there was a big change early in the year. We also saw a lot going on in sick leave, and I've seen we have a couple of folks from Michigan. Michigan had a new sick leave law that took effect in February for 11 or more employees, and then jumped up also for 10 or fewer in October. That was a big change for Michigan. In Missouri, one of the most interesting things we saw in 2025, new sick leave law was passed, took effect, and then was repealed by the legislature. Nebraska has new sick leave. And so sick leave really was a big theme in 2025. And it's something we could see continue into 2026. The other issues that we saw in 2025, AI regulation, certainly a big issue, and we'll talk a little bit about that. Pay transparency, lots of pay transparency laws that came on the books or were adjusted, and some EEO, interesting EEO laws and changes, and we'll touch on those as well. So 2025 was really a very busy year for employment law, and we think that 2026 could be similar or even in some respects more busy. And so now that we've set the table, let me just tell you the agenda for today. We're not going to go over every single law that changed on January 1st, 2026, but we will cover some issues that we think are likely to be hot topics in 2026. So let's jump to our agenda here. And along with the agenda, I'm going to answer some questions because I think we've had a lot of people join, but we'll start by talking about minimum wage and non-competes. Minimum wage, that's an area that changes every year, and we've seen quite a bit of movement. Family and medical leave, I think this is a hot area where changes from 2025 will continue into 2026. We'll talk about AI. Everyone has questions about AI and EEO, and then we'll also touch on pay transparency. And so these are some of the big areas where we've seen change. Let me say this, answer these questions though before we continue. The question we get most often in all of our webinars is, will we get a copy of the slides? And the answer is yes. So we'll send out a copy of the slides. You don't have to take copious notes. We'll send these directly to you. We'll also send a recording of the webinar. And so you can rewatch it, pop some popcorn this weekend, as many times as you want, really catch up on employment law. You also can chat with your fellow attendees using the chat function. And as I said, please put your questions in the Q&A. We'll track those. We'll answer them. Finally, I know that we have mostly small business owners with us today with Sure Payroll. And so this may not be applicable to everyone, but if you do need credits, we are giving SHRM and HRCI recertification credits, and we'll give those at the end of the program. We're really excited about today's program. We love working with small businesses. My wife and I actually have a small business. We use Sure Payroll, and so it's fun to have the Sure Payroll do this webinar in conjunction with our friends at Sure Payroll. And so we're grateful that you're here, and we hope that you can get a lot out of this presentation. With that, we're going to jump right into the substance. Let's first turn to understanding key dates, and I'm going to kick it over to Mira, who's going to talk about key dates and minimum wage. Take it away, Mira. Mira, I think you're on mute.
Sorry. So when it comes to understanding key dates, not all legal changes, not all dates are created equal. The most common are going to be January 1st or July 1st. And unscheduled changes are more likely to happen on the 1st of the month rather than like the 22nd. So it's great to also watch for laws that take effect a set number of days after it passes. But leading into that, January 1st, we've had a lot of minimum wage updates. So these are all updates that are minimum wages that increased in 2026. There's several states. I'm not going to read them all out loud, but you will get a copy of these slides. But with minimum wage updates comes an update for minimum wage posters as well. So many states automatically require employers to post an updated minimum wage notice. Usually minimum wages are usually January 1st or July 1st, January 1st being the more popular option, but these posters must reflect the current rate, including standard minimum wage, tip minimum wage on youth or training wages. And these posters must be posted conspicuously at each work site, even if the payroll site systems are already updated. And if you have remote employees, you also want to send a digital copy to them. And there are about 15 states that have updated their minimum wage posters in 2026. If we could get the next slide. Um, so with these states, they have new minimum wage posters. You can find them at the state's Department of Labor website. A lot of these states also have new posters for different cities and localities, particularly California. In 650, we have a tool that does that, and I'm usually the one updating it. And January 1st, there was so many updates. So that's just something you should look out for. I'm going to kick it to Ryan for non-competes.
Thank you, Mira. So definitely minimum wage, something to be mindful of. I think lots of times your payroll company is covering that, but especially the poster requirement, you want to make sure that you have your minimum wage posters up to date at the start of the year. But January 1st really is not, minimum wage is not the only thing that you should be thinking of. And I think when minimum wage comes up, another thing to think about, and I want to jump to the next slide, is non-competes. I think this is an interesting one because when it comes to non-competes, many states, I guess several states, only allow non-competes for highly compensated employees. And that's essentially employees who exceed a certain salary threshold. So you can only have a non-compete if employees make a certain amount of money. In many of these states, those thresholds are tied to one of three different federal metrics. One is the consumer price index. Another is the federal poverty level, and a third is the state's minimum wage. And so a lot of states sort of peg that highly compensated employee threshold to one of those three indicators. Most of those are updated in January. And so states like Colorado, Maine, Maryland, Rhode Island, Oregon, Washington, and Washington, D.C. all saw their thresholds change in 2026 as a result of those updates. And so if you, as a small business, have employees, maybe you have like a head of sales who has a non-compete, you need to make sure that they're making more money than sort of that highly compensated employee threshold. And as minimum wage goes up and as salaries go up, sometimes you'll have a situation where someone who was making enough, that threshold has now gone up and you can't have a non-compete with them anymore. So make sure that you're keeping track, if you use non-competes, of how much those thresholds have changed and how much your employees are making. Okay, let's jump into something that I think will affect many more of our small business owners today, and that's family medical leave. This is a really interesting issue. We've seen a ton of movement. So let me kind of set a baseline, a foundation for what we're talking about. And I'll start with unpaid family and medical leave. I think most of you have heard of the Family Medical Leave Act, often called the FMLA. And it generally requires, it's a federal law that generally requires employers with 50 or more employees to provide their employees with 12 weeks of unpaid leave for a variety of reasons that are related to family and medical care. So if you have at least 50 employees, you're familiar with the FMLA. Many of you have less than 50 employees. You're probably thinking, well, why is this important? I'm going to get to that in just a minute. So you have sort of this federal framework, but a lot of states have looked at that federal framework and they've thought, you know what? We think that we'd like to provide greater protections to our state, to our employees in our state. And so the way they've done that is they've applied family and medical leave requirements to smaller businesses. So many states have said, okay, if you have 50 or more, you're subject to these federal rules. But in our state, if you have 15 or more or 20 or more, some of them provide more than 12 weeks of unpaid leave, and some have expanded the reasons that employees can use family and medical leave. And so this issue that initially, I think at a federal level was only for larger businesses, those with 50 or more employees, is something that's now affecting smaller businesses as more and more states expand the coverage of family medical leave. Let's jump to our next slide, and we'll talk a little bit more about this interesting new area of paid family and medical leave. So the FMLA provides unpaid leave, But a number of states have said, hey, like unpaid leave really doesn't help our employers. They can't afford to take 12 weeks off without being paid. We need to provide some kind of paid or at least partially paid leave for our employees. And so 13 states plus the District of Columbia now have a form of paid family medical leave. And all of these are funded through a payroll tax or deduction. And so essentially, typically the employee and the employer pays a small amount of payroll tax that goes into a large fund, and then the state helps pay out when people are taking paid family medical leave under the state law. I have a list of the states here. It's interesting. This is how a lot of trends start. You have states on the West Coast and states on the sort of Northeast that start doing things, and then it starts to creep towards the middle. We already see Colorado and Minnesota, and I think this is a trend that we'll see more and more as states realize some of the benefits of giving their employees some paid family and medical leave. Let's jump to our next slide here. So the way that this typically works is that a state will announce it's going to have a paid family medical leave program. It will start contributions so it can fill up its pool. And then at a later date, it will start allowing for employee benefits. And so Delaware is a great example. They started their payroll contributions January 1st, 2025. And just a month ago, January 1st, 2026, employees could start to get benefits. They could start to take that paid family leave. Maine started their contributions January 1st, 2025. For our small businesses in Maine, their employees will be able to take this paid family medical leave starting in May 1st, 2026. So coming up. I live in Maryland. We've been trying to put this in place. Our payroll contributions now start July 1st, 2027, and the employee benefits, we're not sure when those will kick in. So this is not the easiest kind of program to implement. Maryland's had a little trouble with it. Minnesota took an interesting approach. They just said, we're going to start taking contributions and benefits. We're going to start them both January 1st, 2026. So if you're a small business in one of these states, you need to make sure that your payroll system is helping you to have the contributions that you need, and you need to understand kind of how this law affects your employees. Let's jump to our next slide here. And I'll just talk about a couple additional changes to paid family leave. So I talked about states that are still in the process of launching their program, but some of the states that have already launched their paid family leave programs are starting to make some changes. And so as they've administered the program for a year or two, they've realized there's some things they want to do to improve those programs. And so let me give you some examples. Colorado extended the duration of their paid family leave for an additional 12 weeks for parents or a parent who has a child receiving inpatient care in a neonatal intensive care unit. I thought this was a really interesting change, certainly important for those parents that find themselves in this situation. And it'll be interesting to see if other states follow this example. It's kind of a narrow area, but for those parents that have children receiving inpatient care in a neonatal intensive care unit, this kind of leave could make a big difference for them. Rhode Island expanded they call theirs temporary caregiver insurance benefits from 7 weeks to 8 weeks. So that's an example of a state saying, okay, we've given 7 weeks of paid leave. Let's move and make that 8. And then Washington has expanded the job protections to smaller employees and employees who have worked for less time. So as part of their paid leave, they could take the paid leave, but they also receive job protections, and they have decided to apply this to even smaller businesses. And I think this is an example of how, paid leave in the past or family medical leave really only affected larger businesses. But in Washington now, even smaller and smaller businesses need to provide this leave, and their employees are protected, meaning that they can come back to their jobs. And so I think that's an important change as we see this type of leave affecting businesses of all sorts of different sizes. With that, we've covered a lot on unpaid and paid family leave. I'm going to turn it over to Seth, who's going to talk about one of, if not the hottest topic in employment law, AI. Seth?
Thanks, Brian. Yeah, so I'm going to talk to you guys about some AI, no, some new types of AI litigation that came out basically toward the end of last year and a few from the beginning of this year as well. And specifically, I'm going to be focusing on the intersection between AI and employment discrimination, which kind of at first glance might seem like an odd combination of topics, but it's really not because we're kind of in the early stages of AI regulation, right? And governments don't quite know what to make of it yet. So most regulation up to this point is going to be has been very targeted at the area of employment discrimination specifically, because I think a lot of states are concerned that employers might use AI tools either without fully understanding how they work, or maybe using them in the wrong kind of context, or just getting a bad tool that is going to produce flawed outcomes and use them in ways that could disproportionately affect workers and applicants of protected based on a protected class, right? Which are typically things like race, age, religion, national origin, that sort of stuff. So at least so far, we've seen a really heavy focus on this specific area when it comes to AI. And we're going to kind of talk about five examples here from the last several months. One out of Colorado, one out of Illinois, one out of New Jersey, one out of California, and then one out of federal law. But even if you aren't operating in those specific states, I think this is still helpful information because I expect to see a lot of other states follow these guys' leads. Specifically, the kind of rules that came out of Illinois, New Jersey, and California are very simple and straightforward. And I think it's likely that we see most states do something like that here in the near future. But before I jump into the specifics of those laws, I want to talk a little bit about what we mean when we say AI, which is going to come here on the next slide. And because I think when people hear the term artificial intelligence, right, you think about kind of like very advanced pieces of technology that are almost trying to emulate or replicate human intelligence, right? Things like ChatGPT and Gemini that you can kind of have a full conversation with. And that certainly is AI, right? That's one type of it. But governments and the regulations they create define it a lot more broadly. It really is going to be any type of machine-based system, so any kind of like automated process that basically takes data in on one end, analyzes it in some way, and produces outputs, being like recommendations or predictions or decisions or something like that. Really, the most common place we see this come up for employers tends to be basically vendor acquired tools, right? Especially things like resume screeners. There's a number of lawsuits going on right now against companies who produce basically algorithms that screen resumes and give recommendations on who to interview and who not to interview. And we also see it in performance monitoring technology sometimes, which can be, if you have anything installed, or I guess if you have to give employees computers basically, and you have anything installed on there that kind of monitors when they're active and when they're not, in certain circumstances, that can kind of qualify as AI as well. Really, it is just about that sort of black box with data coming in and recommendations coming out the other side. That's the only requirement to be considered AI in the context of the stuff we're going to be talking about today. And for that reason, you see a lot of bills out there refer to it as automated decision-making technology or some version of that, rather than using the broader artificial intelligence word, which I just bring up because it's important to kind of understand that AI might be getting into aspects of your business where you might not always or necessarily intentionally be putting it there, if that makes sense. Like tools that don't seem to be AI can legally be considered to be AI if they meet this definition. So with that, let's go ahead and jump into the first law that I'm going to talk about today, which is Colorado's Artificial Intelligence Act. And it's was one of the first regulations of AI at all, but it's also the first comprehensive regulation of AI in the United States. And what I mean by that is it tries to regulate the use of AI at all levels of the economy and in all industrial sectors and in all types of uses that you can have for it, basically. In contrast to some of the more focused laws we'll talk about here in a little bit, which only really try to take out one specific aspect of AI use, which in a lot of the cases is employment discrimination, like I talked about earlier. But Colorado went broad, tried to kind of take the whole apple down in one bite, if you will. And it regulates both developers and deployers of AI. Developers are people who actually make the tools, so that's probably not going to be relevant for most of the folks here. But if you do happen to be making an AI tool, be aware that this could apply to you. But it also applies to deployers, which was basically any business that uses AI in connection with some kind of significant decision, right? So again, we're talking about screening tools, performance monitoring, that kind of stuff. There is a threshold though, so this might not apply to a lot of the smaller businesses here. It only applies to employers with 50 or more full-time employees. It also is going to take effect in June of this year. It was delayed a bit from the start of the year when it was supposed to originally kick in. On the next slide here, I'll just go over briefly some of the regulations that apply to deployers in case this does apply to some of you folks. It's really kind of simple. The only rule that's in there is that you have to use reasonable care to prevent algorithmic discrimination, which really means you have to act reasonably and try to prevent the AI from discriminating against people. It's kind of that simple, which can take a lot of different forms, right? Maybe I'll go back, kind of take a step back here and just give maybe a brief explanation of how AI can discriminate in this way, right? Because the thing that the government is concerned about is that if this AI is recommending who to hire or who to fire based on a bunch of criteria, it might either inadvertently or intentionally be recommending people who are typically part of one racial group or part of one religion or part of one age or whatever it might be, or based on the basis of any kind of protected class. So essentially, they want you to act to make sure that the AI is not being biased in the recommendations or the decisions that it makes. And there's no specific set of rules for like how you have to do that. But they do provide this kind of list of things where if you do them as a deployer, you get what lawyers call a rebuttable presumption, and what most folks would probably think about is the benefit of the doubt, basically, that you used reasonable care, meaning that, a court will just kind of assume that you did unless proven otherwise. What you have to do is have a risk management policy in place for any of these AI systems that are making impactful decisions. You have to complete an impact assessment of kind of the effect that they might have on the people, the employees, or the applicants, or whoever they're sort of deciding things about. You have to notify people who might have decisions made about them by the AI and make a statement publicly available, kind of like a privacy notice that would just summarize what the types of high-risk AI systems you use. And then in the event that you do discover that your AI has been discriminating, you have to kind of proactively notify Colorado as Attorney General that you found that. And we're going to see a little bit of this as we go through, but really this core idea here is just doing some due diligence to make sure that the tools that you're using have been vetted and are not biased, which can be done in-house, but that could maybe be a bit of a heavy undertaking. So maybe the easiest way, and what we usually recommend, is to talk to the vendors. Anytime you're getting one of these AI tools, speak to the vendors and make sure, or see if they've done a bias audit, or if they have kind of documentation that they can give you to show that the AI is producing unbiased results. It is a good way to go about it. Before we jump into the next one, I think we might have a question. Ryan?
Yes, sorry, I've been furiously answering questions. The question was about 50 employees in Colorado, and it's my favorite question that we get all the time. Is it 50 employees in Colorado, or is it 50 employees total?
A great question. Yes, I would say it's the one we've been asked the most since I started at SixFifty. And unfortunately, the answer is a little bit uncertain. The law does not specify whether to count employees in the state or kind of nationwide totally. So it comes down to kind of your business's level of risk tolerance, really. We generally say it's a best practice. It's a safer practice, at least, to assume that they mean nationwide employees, because then, you're complying with all the laws that could apply to you. But then you run the risk of, putting in a lot of time and effort and money to comply with laws that some court decides don't apply down the road whenever they clarify this question. So it's a bit of a mixed bag.
A second question, and I know that you touch on this, but I think it's an interesting one. The question is, how do you ensure that an AI system isn't biased?
It's tough, and there's not really 100% black and white way to do it, but kind of in a nutshell, what you want to do is run it a lot and try to see if it is producing, disproportionately positive results based on ethnicity or something like that. So if we use the example of a resume screening tool. If you send through a bunch of resumes of folks with like white sounding names versus members of, Hispanic sounding names, and you see that it is disproportionately recommending one over the other, that's kind of the basic concept of a bias audit. But doing it thoroughly and really understanding kind of how the tool works is another helpful piece. Like, you want to make sure that you get what pieces of information is this tool looking for, right? And which ones of, is it looking for any information that might be kind of um, like a heuristic or a shorthand for a protected characteristic, right? Like, age is an easy one. If you had a resume screening tool that was really, really prioritizing people with longer work histories or more schooling, or what have you, that could theoretically be accidentally discriminating based on age because it's prioritizing experience so much. That's kind of one example, but there's a lot of ways it could happen. And really, the best way to kind of go about it, I think, as I mentioned a second ago, is to just make sure you have a good dialogue and a good relationship with the vendor and get as much information as you can about the tool and ask them, how do you know that this isn't biased? And often they will have run some of these bias audits or impact assessments that they could share with you and kind of walk you through that process. And then you just ultimately got to decide, do you trust it or not? And that's sort of the judgment of it all. So with that, let's move right ahead into our next law here, which is coming out of Illinois. And now we're getting into a much more simple territory than Colorado. And again, we're kind of focusing in really hard on this discrimination piece. And what Illinois did, and this is something I think was very likely to see other states do, and in fact, a couple I believe have already or are in the process of doing it. But essentially, this just amends existing discrimination law in Illinois. So all of the standard rules and things for employment discrimination in Illinois functionally just are applying to AI now. And they did that by just throwing in one paragraph at the end, basically saying use of AI in connection with any of these decisions you see here in green, like recruitment, hiring, promotion, renewal, training, discharge, all that stuff, in a way that results in discrimination, even if you don't intend it, based on any protected characteristics or zip code, is unlawful as and treated as any other type of discrimination. And the zip code piece is kind of interesting. That's a new thing we're seeing a few states start to hone in on. But basically, Illinois has found, or believes, I suppose, that zip code can be used as a proxy for protected characteristics because people who share certain characteristics, like maybe religious background is a good example, might live in the same place. Perhaps they're by a church or a place of worship, or if income was a protected class, you could maybe group people by their income based on zip code. So they're adding it to the list and saying, hey, no geographic discrimination either. So that's something you want to keep in mind if you're hiring folks in Illinois. And just a little piece here, if you are subject to this, it's requiring you to notify an employee or whenever you're using AI to make one of these kinds of decisions. So be sure you're doing that if it applies to you. Moving right along into California, which did something very similar. It's a little more built out than Illinois. I wasn't kidding when I said Illinois' amendment was really just one paragraph at the end of the law. California released a whole page or a whole packet of regulations last fall, basically functionally doing the same thing that Illinois did, but explaining it a little bit more and providing some more detail. But really, they're just saying, hey, all this stuff, all this existing employment discrimination rules we have are going to apply to AI. So no using AI to discriminate on the basis of any protected classes. And where California goes into more detail that can be kind of helpful is they include some specific examples in their definitions. And one that I pulled out here I thought was kind of interesting is assessments that make predictions about applicants or that measures their characteristics. So that's going to include those screening tools we've been talking about a lot, but it can also include sort of tests that you might give people during an interview process. Like, I remember before I started at SixFifty, I was given it was an emotional intelligence test. It was some kind of thing where they like would show you people's faces and try to ask like, what is this person feeling? How might you interact with them kind of based on their emotional state? And then if that quiz was graded on kind of in an automated way, and I was given a score by a computer, that would then qualify as AI, right? Because you have that same data on one end being like my answers to this quiz, outputs recommendations on the other being a score. So that's something to consider if you're using any of that in your hiring process, or I suppose if you're, eligibility for promotions and the like. Another interesting thing that we see here, kind of similar to Colorado, but it basically has a little safe harbor or a little benefit of the doubt space for employers who do this bias testing or audit technique or use it or audit in some way their AI tool to prevent it from discriminating. So if you've done that, you can keep the report on file. Maybe you got it from the vendor, maybe you hired a third party firm, maybe you did it yourself. You keep that on file, it's going to give you that benefit of the doubt of saying, okay, even if the AI was in fact being a little discriminatory, maybe there's not going to be liability attached because you showed that you kind of did your due diligence there. And this really is kind of the punchline, and I know I've hit it a few times, but it's a best practice to make sure that any automated tools that are involved in big decisions have been bias tested or audited in some way. That's just a great first step that pretty much everybody should take when you're using AI in this way. Only other thing I'll note here is if you are subject to this, you have to keep records of the data that you fed into the system and the outputs it produces for 4 years in the event of an audit or something like that. So make sure you're keeping records if you are doing that in California. Our last state example we have here is sort of the lowest lift way to deal with AI, and actually the one that I think is going to be the most relevant because states can do this without having to pass a law or without having to really put forward any legislative effort at all. And what they did is, so New Jersey's Attorney General is responsible for enforcing employment discrimination law in New Jersey. So the Attorney General wrote a memo. It's about 14 pages long, and it's actually a very good summary of how AI can discriminate, and it gives some examples of how you might be able to kind of look and see or assess the bias of it. So if you're interested, I recommend downloading it when you get the slides. The blue underlined thing in the title is a link. But so they wrote this memo saying, I, as the Attorney General, have decided that existing employment discrimination law already does apply to AI use because it's just another way to make employment decisions, right? It's not fundamentally different. And so in doing that, they functionally I think it has the same effect as Illinois' legislative change, but it was all able to be done just by one person kind of putting out this opinion and deciding that they were going to enforce the law in that way. The substantive requirements of this really don't change, right? Because they're not adding new rules to the anti-discrimination law. They're just sort of saying that it already applies. So again, just when you're using it in the context of these significant decisions, hiring, firing, promotion, all that stuff, you want to be extra careful. And there's an interesting note in there too, where it talks about specifically getting reasonable accommodations for like the ADA and disability law. If you were to be using some type of a program like I don't know, a chatbot or what have you to let employees submit these requests, and that chatbot in some way made it hard for people to get accommodations, that could be a discriminatory effect, at least in New Jersey. I thought that was kind of an interesting point and not a type of AI discrimination that might immediately come to mind. So be aware of that. I think it's going to be widespread soon. I think a couple states have already followed New Jersey's lead in kind of doing this. So even if it doesn't apply to you yet, there's a good chance it will at some point. And my last law in general that I have is going to be a little bit of a federal note, which is kind of a huge asterisk on all of this. That the feds might try to deregulate, meaning basically nullify some or all of the laws that we've been talking about today and AI regulations in general. There was an executive order, I think, in December, basically directing the Justice Department to make a task force of lawyers and essentially challenge the validity of state regulations in court. There are a bunch of different arguments they could theoretically make to say that these laws are invalid. I won't bore you with the details of those. But the focus is laws that are inconsistent with the policy set forth in the order. And that policy is, and I'm quoting here, to sustain and enhance the United States global AI dominance through a minimally burdensome national policy framework for AI. Which, to translate that into normal speak, is really the policy is to not have burdensome regulations on the use of AI in the United States across the board. So that at least means that there's going to be a push to roll back laws, and I don't know for sure, but if I was a betting man, I would put it all on Colorado's AI Act being one of the first they go for because of how widespread those regulations are, right? They really apply to a lot of different things and place a lot of burdens on tech companies. We don't know yet what they're targeting. There's actually a report they're expected to release in March that would give a little more information about specifically which state laws they've decided are inconsistent with the policy. And they're also looking to potentially withhold funding from states with AI laws as sort of an alternate method to maybe try to get them off the books if the court thing doesn't work. So this is just kind of a thing to say keep an eye on this. It could develop. It probably won't have a huge effect on employers, even if they do end up deregulating a lot of this stuff, other than maybe removing some of the liability risk associated with AI. But I think a lot of this core thing, the core things we've been talking about today about not using AI to discriminate, I think that's going to kind of stay around, even if the feds do get some of these broader AI schemes thrown out. But only time will tell on that front. So the very last thing I have for you today, before I kick it back to Ryan, is just a little note on protected characteristics. We just kind of wanted to highlight that states are adding a lot more maybe unusual or non-traditional types of characteristics that they're protecting under discrimination law in 2025 and 2026. Here's a list of some of them here. Gender expression or justice impacted status, which means criminal history. Height and weight, also in Minneapolis, is kind of interesting. So just be aware of that. It's a trend we've seen for a few years. If anybody remembers, there was a bunch of bills called Crown Acts that were passed back in the day, basically saying that hairstyles can be discriminatory. So just keep an eye on this in your state, in your locality, and make sure you're up to date on those different classes. And with that, I will kick it back to you, Ryan, I think, for pay transparency.
Yes, before I dive into pay transparency, let me just raise one issue that I think has been
Oh,
interesting
sure.
in the chat. And I think part of that is someone asked essentially, how can I prove that I'm not using AI in a discriminatory way? And it sort of made me think that I think one of the best things that businesses of all sizes can do is to have an AI use policy that explains clearly when AI can be used, what type of information can be put into it, what types of AI tools can be used. And, I think even for very small businesses, if you don't have that kind of policy, then your employees may be using AI when they shouldn't, or they may not be using AI when they should, right? AI can really be something that helps people to be more efficient in certain circumstances. And so I do think that it's smart to think that through and to have a clear policy that says, hey, you should use AI when you're generating marketing material or when you're, preparing something of that nature, but you should not use it, for example, when you're trying to forecast our revenue for the coming year. That may not be the right time to put your proprietary business information into an AI engine. Also, there's so many different applications, right? AI happens when you put things into Google now. You can use Chat or Anthropic or Claude or whatever you want to use, but it can also be helpful to let your employees know what they should use. So I actually think that an AI policy for businesses of all sizes is one of the most important policies you can have so that you can avoid any sort of situation that would even come close to some of these that you've talked about.
Great points, I think. And I would just add, just to kind of echo, the easiest way is just not to use it, again, in connection with these really big, significant decisions around hiring and firing and that kind of stuff. But, it's up to you at the end of the day how much risk you're willing to take on. So,
yeah. Well, thank you. Great questions. I'd remind you, I've seen great questions in the chat. Put them in the Q&A. They're a little easier for us to follow, but a lively, good chat going on as well. Let me jump into pay transparency. I think this is one of the areas where we've seen the most movement, I would say, over the last 3 to 4 years, and we continue to see movement, and I think we will continue to see it in 2026. I mentioned when we were talking about paid family leave, how many of these things sort of start on the West Coast and the Northeast, and they work their way to the middle. That's a little bit how pay transparency has been. Started sort of on the West Coast and the Northeast, and now, as you can see, it's really filling in. And we have 36 jurisdictions, including DC, that have some type of wage transparency protection. As I mentioned, 2025 was a big year for pay transparency. We had 6 new laws that became effective in 2026. So that's a big change. And I think we'll see more in 2026. So when we say pay transparency, it's sort of an umbrella term that covers a lot of different things. We sometimes break it into passive and active requirements. A passive means that an employer can't prohibit their workers from, for example, discussing wage. There's things they can't do. And then active is disclosures. And I think a lot of people think about that. For example, putting a pay wage range in your job postings or disclosing pay ranges or pay amounts to your employees. So lots going on in pay transparency. Let me show you just a couple of examples. And I'm going to do this relatively quickly because I want to save some time. But we saw, I think, interestingly, pay transparency laws both in localities and in states. So Cleveland, Ohio is an example. October 27th, so near the end of 2025, it affects employers with 15 or more employees. They have to include a pay range in their job posting. And so this is an example of a city rather than a state. And we've seen counties do the same thing that are adopting pay transparency. And so that's an important thing for people to think about. It's not just the federal government and the state government. You also need to know your localities. Delaware also adopting pay transparency, where they have to include pay ranges and a description of job benefits in all job postings. And that's becoming more common as well. Do you provide insurance? Do you have dental? Is there a 401k? Those kind of things also in many of these pay transparency laws are being included. Illinois is another example. And let me sort of touch on that briefly. A couple of states, Illinois, California, has a similar requirement, have said, hey, for larger employers, we're going to have you actually file your pay data with the state. And so you can get what's called an equal pay registration certificate in Illinois. And that way, the state can look to see and make sure that you're not paying people in an inequitable way. Kind of interesting. Also, Illinois has this prohibition that took effect January 1st, 2026, prohibiting an employee from engaging in a protected, concerted activity to address work-related issues. And so that's often kind of what I mentioned as a passive protection, where you can't stop your employees from talking about things. New Jersey also came out with a new pay transparency requirement where you have to include a wage range in job postings. So kind of interesting. I think these are things that are really gaining traction. I think we'll see a lot more of this in 2026. Let's jump another slide. I'll tell you about a couple more things when it comes to pay transparency. Massachusetts is another example. If you have 100 or more employees, they have to provide wage ranges to DOL. So like Illinois, like California, I think we'll see more states do that. Washington is an interesting example. In Washington, they came out with a pay transparency law that required people to put a pay range in their job postings. But different than a lot of laws, they made what's called a private right of action. And that means that a citizen can actually sue a business if they don't comply with the law. Typically, these laws are enforced by like the attorney general or a member of the state government. But in Washington, they allowed this private right of action. They were then businesses were flooded with these suits. And so that's kind of the danger of a private right of action. The legislature then stepped in and said, hey, instead of suing, you have to give them notice and 5 days to add a pay range to their job posting. And so I think that's an example of, one of these pay transparency laws having a very concrete effect on Washington businesses of all sizes who have to put those pay ranges in. And then Vermont also, they have to use a good faith pay range for jobs. That's employees with 5 or more employees. So lots of things going on when it comes to pay transparency. I want to touch just briefly on California. If we can jump to the next slide. California also has long had a pay transparency, but they passed some regulations that explain that the pay scale must be a good faith estimate of the range. I think they were having some problems where they were like, well, we'll pay someone something in between $20,000 and $200,000. There's a range. That's not actually what they mean. It has to be a good faith. And the wages now equal all forms of pay. So that includes bonuses, stock options, benefits, etc. You have to put all that into the wage. And then this is a big question that people have. In California, employers must now keep job title and wage history for 3 years. So if there's an investigation, you have to keep that information so that investigators could come and look at it. So I think that's really, really important. The last thing I want to touch on when it comes to pay transparency is pay stubs. This is kind of an interesting issue that I think we'll see more movement again when it comes to pay stubs. So starting in April, so early in 2025, employers in Ohio have had to include the employer's name, their address, and then the gross and net wages, each addition or deduction, and a date of payment and pay period. And there's some additional requirements for hourly workers. This is actually an important part of pay transparency, is that people need to understand their pay. Why are they getting the amount that they're receiving? And Ohio has passed this law. I think we could see a lot more states that jump onto this bandwagon. Similar in Oregon, they have to provide a detailed written explanation of all potential earnings and deductions at the time of hire. So when you hire someone, you really have to detail that. So lots of different ways that we're seeing pay transparency in these different laws. And I think that that's something you'll continue to see in 2026. And I think it's a really important thing for businesses of all sizes to pay close attention to. So I want to we often get, I think, an interesting question, which is, how do I keep up with all of these changes to the law? And I'm going to just share my screen for a minute. I'm going to show you this tool that we, SixFifty, it's a Sure Payroll Power or tool powered by SixFifty that can help with this process. And I think it's an interesting one. So I'm going to jump right here into this tool. This is the SixFifty Sure Payroll tool. It comes with two things. One is an employee handbook builder, and the other is this sort of research. And there's lots of tools out there, but I want to show you kind of how this tool works. So this is a tool where it lists all the legal updates. So as the law has changed, you can see both the notice date and the effective date of when the law has changed. And maybe you're just in one state. So say you're in California, you can click here and you can get just the California changes. The other thing that I like about it is you come down, you want to know a locality. So here's Los Angeles County, or, as you come farther down, Belmont or East Palo Alto. And you can click on these and it will give you a write-up of what the changes are. Some of them, many of them, as we talked about, are minimum wage. The other thing that's interesting that you can do with a tool like this, and I think there are some similar examples, is you could come over to the calendar view and pull it up in calendar. So if you're thinking, oh, I want to put these on my calendar. So here's Colorado, they've got this rule here, and I want to add it to my Outlook calendar or my Google calendar. You can kind of see how the laws are changing and add them to your calendars. As you see, March, not the busiest month, but if you go back to January, things were pretty crazy as things changed a lot. And so this is a way that you can go through. And then I want to just show you quickly, a lot of people say, well, I get the changes, but how do I put them into my policies and my handbook? So we also have a handbook builder. This is available, and we have a link here on the next page that'll show you where you can, through Sure Payroll, get this SixFifty powered handbook that will help you to generate handbooks. I'll just show you how this works. If you jump right into the question flow, we'll ask you a series of questions about your business and help you to generate a handbook. So we'll ask you where you have employees, what kind of handbook you want, the types of things you want, and you can generate different kinds. For example, this is a handbook that has all of your policies right in the middle of it. So I just did Maryland and New York. Our small business is in New York State. I live in Maryland. And so it'll have all the policies you need. The other kind of handbook you can generate is a core handbook with an addenda. So you can go in, you have just your core policies, and then you have all your New York specific and your Maryland specific. The nice thing about this kind of handbook is as you add someone in a new state, you can often just add a new addenda. And so there's lots of information here, but I thought I'd just show you. People often say, well, what do I do with all these changes? There's ways that you can track them. There's ways you can put them into your handbook. We push your changes into your handbook, and that's kind of the way that we do it. There are a lot of great tools out there. So that's a quick look at the Sure Payroll Handbook Builder powered by SixFifty. If you want to learn more, you can click on this link when we send you the slides. You can also put click yes to this poll, and we'll have someone from Sure Payroll reach out to you to give you a little bit more information about this sort of joint offering. Okay. I also want to just mention we have certification codes for those who would like SHRM or HRCI credit. I'm going to read those out loud so that they're captured in the closed captioning. Our SHRM recertification code is 26-732N7. Our HRCI code is 733-680. Again, that's 733-680. And so I want to just answer a couple of questions that came in. I've been trying to answer those in the chat. But if Mira and Seth want to join me, we'll go over just a couple of quick questions that were posed during the webinar. We try to save just a little bit of time here. So one of the questions that I got, Mira, is what should we do for remote employees when it comes to posters? Do we need to print those posters and put them in our physical location if the employee lives in another state, or how do people generally handle posters when they have remote employees? Oh, Mira, you're on mute.
Sorry. So if you have a physical work site, you definitely want to print them out and have them in a place where employees can see them. But if you're remote employees, the best way is probably to just email a PDF. But remote employees should have this information as well.
Yeah, great answer. And we actually created a poster tool for this very reason, because a lot of people are like, well, what do I do for my remote employees? We have a tool where you can just click on the posters and send them to them. You don't need to put the posters for every state in your, if you only have a physical location in one state, you don't need to put the posters for every state where you have employees, because they're not going to see it. They're not often at those places. So interesting development when it comes to posters. We had several questions on how do I know which law applies to my employees, which is kind of one of our top questions. Seth, do you want to take that one? If you have, sure, for example, an office in Texas, but you have employees that work remotely in Arizona and Oklahoma, which law generally applies to those employees?
And I'm happy to be able to give a little more definite of an answer to this question than I was to our other most commonly asked one. In general, it's going to be the state where the employees perform their work specifically. So and I'm using that word carefully here, because if they work from home, then that is going to be the place where they live. But if they, let's say, live in New Jersey and commute to Pennsylvania, and the business is headquartered in Georgia, Pennsylvania is likely going to be the one that applies. There can be a little bit of nuance there, like where you have employees who maybe split their time evenly between two states, and in that case, it can get a little muddy. But if you have somebody who works in one location for at least the majority of their hours, that's going to be the law that you want to follow 90% of the time.
Yeah, we got variations of that related to FMLA and a number of other laws that we talked about, and that can be a tricky issue with remote employees. But generally, for example, the example we often use is if you live kind of on the Washington-Oregon border, maybe you live in Washington, but you commute to Oregon, and you work in the office in Oregon 3 days a week and you work at home 2 days a week, Oregon employment law probably applies to you, because that's where you're doing most of your work. You're 3 days and you're only doing 2 in Washington. If it's the opposite, if you're working from home for 3 days and you're only going into Oregon for 2 days, then Washington law probably applies. And so generally, it's the law where you do most of your work. And I think that's an important thing to remember. I think a lot of people wish that small businesses wish that it was where they were based, that they just applied that one set of laws. But unfortunately, it's more based on where you have your employees. So we are at the top of the hour. We've gotten a lot of great questions. Here's an interesting one. Seth, I don't know what you think. Someone says that they own a food truck. Where can they post posters for their employees? They have such limited space in their food truck. Interesting question. Mira, Seth, any thoughts on what we can do there?
Yeah, that's interesting. And it might come down, it might depend a little bit on the state you're in and how kind of rigidly they define conspicuous. But I think something that's like a clearly marked binder where everybody knows where they are would likely still qualify. Potentially, especially in some states that are more chill about remote work, you could potentially do something like an intranet or like a Google Drive folder that everybody has access to, and maybe put a QR code on the wall or something like that. But it is going to depend a little on where you are, I think.
Yeah, I think just to be safe, I think it might be a good idea to send a PDF to each employee. Better safe than sorry. But I think a binder is a good way to have those posters as well.
Yeah, I like the binder idea as well. Okay, we got tons of great questions. Thank you so much for joining us for this Short Payroll 650 webinar. We hope it's been helpful. We've enjoyed having you here. We hope you'll join us in the future for a future webinar, and we wish you a great day. Thanks again for spending your afternoon with us here at 650.